Hi, welcome to my channel. Good afternoon. Today is 24th of June 2022. I'm Thomasin PA 2066. This afternoon we like to bring a topic called Right of Way. This topic is related to easement in the land law. Let me begin. Hey, hello, welcome to my channel. I'm Thomasin PA 2066. This is a extension again on the Fine Way series for probably topic related to basics. This is regarding land law, right of way, property investing and selling issues. I have done more than 22 chapters on this topic. A lot of people would ask this topic. However, not much of a material has been done on this topic before. So right of way, in the discussion, we would zoom into the National Land Court as well as the Sarawak Land Court. Let me start. So easement is the name which is to be remembered for the topic on land which affected by no entrance. That means the land is surrounded by other land and the owner of the inner land has to gain access to his land by using other people's land. So the right to use another person's land for a specific purpose. Of course here it's in the small writing. You can see that right of way on the side of the right hand, and then on the left hand, right to light. So it doesn't mean that it has to be a road which comes into this inner land. It can be a positive part which is using a way entrance like a road, but then it's looking at it at the negative part, saying that you block my sunlight. So the way of entrance of the sunlight is actually also an easement. So this part, if a block of building comes out on the next to you and you are blocked by the building and therefore no access to light, then this means negative part of the easement where a building block out your light source. So this is the negative type of easement. Positive type of easement is on the part that you make an entrance or using another access to your land. So there is a picture here, Mary's land and Tom's land. So easement means Tom's land. In order to get into Tom's land, Tom has to use the entrance which land under Mary's control. So Tom is allowed to go through Mary's land to get to the road. He has an easement. So this easement in the way in the old days probably is just a kampong road. Now it can be in fact a constructed road, or indeed not just road. It can be even river or stream, as long as there is a need to enter to the inner land. So in the summary, just to briefly know what easement is actually a right to use another person's land for the specific interest. And this usually need to be registered in the land office, and if eventually both lands are owned by the same owner, then this easement automatically ceases, because there's no point already having this easement. So this easement is basically to protect the inner land so that it has a right to gain entrance. Of course, later on we will talk about right of irrigation, right of drainage, and all those disposal of wastewater. So this type of situation is of course provided in the law. And there is also one important issue here, that is if there is no registration, no matter how nice the other landowner is, there is no easement. So if Tom in this case has been using this easement entrance but never register it, and one day Mary doesn't like Tom, Mary can shut off the entrance. So this is what it is in the land law. However, we are talking about a topic called right of way. So right of way is actually different a bit from the in the way the topic of easement. So right of way is a specific part of the easement. Easement is in fact a broader term, and right of way is more of a specific term. Later we will show you in different land court. There is a different, in this case for Sarawak Land Court and West Malaysia National Land Court. Later on we will see. So right of way indeed is referring to the exit for dominant parcel A through the servient land parcel B. So we have to understand the term here, servient land and the dominant land. Dominant land means the inner land. Why is it dominant? Because it needs entrance, and the law provides that it is allowed for this entrance, and this means that he is dominant. He is able to dominate this power over servient land B. So he may have to compensate B, yes, but then it is his right, so he's more dominant. The law protects him. He is more dominant than B. So let us compare in a simple way what is easement, what is right of way, and what are the differences between them. This reference I get it from askanydifference.com, which is not Malaysian specific, but anyway, the concept of easement compared to right of way is different, interpreted here as right of way is a subset of easement. So easement is a bigger thing, and right of way is a more specific, smaller thing. I have to put it that way, easier to understand. One is the permit. Usually the easement site is used for somebody else's property inside a agreed term in the land court or in the land law. So that means the person say, I want to establish an easement. So this easement means it is put into the documents of the registration of the title of the land. So right of way, more of like, because I have to enter to my place, therefore I use your land for the purpose only. So it's more like no choice but to use your land. So like I am an archaeologist, I go into the land to do work, but then I use your land for putting certain things, and therefore I need an easement. Whereas right of way means I enter to your land in order to reach my archaeology site. Then that is a right of way, just only for an entrance. So here it puts as a passageway. Relation, it is the main subject. Then for right of way, it is part of the easement. So here easement means a bigger thing, whereas right of way is a part of the easement. So scope, as you say, easement is broader, and then right of way is specific. Type, it can be of few types, not just two types. Whereas right of way usually is only for one type, that is entrance or passageway. Part covered, it can be different part. You can have a few easement affecting the servient land, but then for the purpose of right of way, it's usually only one specific part and only that particular passageway. Okay, I refer most of the reading to Saleh Buang's book on Malaysian torrent system, second edition. Well, the key terms of easement and right of way, just we go through again. Right of way is more for passageway, pathway, or pathway in order to enter to the inside land. Inside land here is dominant land. Then the outside land which is surrounding it is actually the servient land. And easement, we talk about specifically right of way within the bigger, broader terms of easement. Easement can be anything like the example just now, archaeology site. I go into my land for doing archaeology work. I have to maybe pass through your land, as well as need to go through certain processes to build my tent and build my other things in which you encroach into your land. And this is for a purpose of putting my tent, then therefore the easement need to be established for that area which I encroach. Then the easement need to be established for the place that I encroach into the surrounding land. So this is broader in terms of the purpose, whereas the right of way is a more specific entrance purpose. So the part on the right of way touches on natural rights because you just can't physically enter inner land without having an entrance. So this is trespass. If you say you enter into another person's land without his permission, it's trespass. So in order to protect the inner land right to exit and to enter, then it has to be a natural right for that to be protected So there is a law in the land court that says right of way is a natural right Of course, in some cases they put this under land administrator's right of way So the land administrator has the right to enter whichever land is in inner land without having to ask for the permission. So there is two category. One is private right of way. That means a specific group of people and not everybody. But then there is another one called the public right of way. So this public right of way means anyone on public can use that way to enter into the inside inner land. The other part is the licenses. So of course, easement is a registrable instrument into the land court, land law, in saying it is actually registered in the land title of the land. Whereas you can establish license to specific entrance or specific how it is given that entrance to the inner land. So these licenses are also issued by the land office. However, there are two other types of arrangements which provides entrance to inner land, but it's not in the national land court or not usually not registrable type of instrument. It's actually restrictive covenant, and another one is profits perdue. I also don't know how to pronounce this. Pradi. But anyway, these two types of common law equivalent now of entrance to inner land is actually on agreed terms. It's something like agreed term between the parties of inner land and also outer land. We move on. So on the part on land administrator's right of way, it's actually in the part 28 of the National Land Court of the section 387 to 395. The part on it is actually public terminal, which is for shore or a river, railway station or public road. So this part, it means that the inner land has to accessible to this public terminal so that it can be used. The land inner land can be used. So this we want to emphasize. It's not just road system. It can be a foreshore, or it can be a river, or it can be a railway station. So as long as the inner land need to achieve this transportation or access, then it has a right to ask for land administrator's right of way. So the section 388 in land admin's right of way actually say the land administrator may create a right of way over land which shall be known as land admin's right of way. So this is in the National Land Court, where when inner land need to has accessibility, then it goes to the land administrator, and land administrator would agree on the right of the way and put it into writing. So let us go into more detail. So generally, the right of way is a subset of easement, and in Sarawak Land Court, although there is no specific section on easement, there is a section 34 specifically talks about right of way. So this part is quite interesting for Sarawak Land Court. There is a reason for it maybe. So in the first schedule of the Sarawak Land Court prescribed forms, you look at form G1, grant of right of way, right of easement. So this form looks like this. the servient landowner, proprietor, and the dominant land proprietor. So it's the grantor for the considerations specified below. Hereby grant to the grantee the right of way. So grantee is dominant land and servient is the grantor, the outside land. So the outer land gives the right to the inner land to use the entrance and to be paid a certain amount of money. So there is a form to be used, to be given to the land office. So the land office will process this. Also this form G1. So anyway, Sarawak Land Court put 34, section 34 right of way as an implied right. It's implied. That means you do not need to really go and do it on paper. It is an implied right for the land, inside land, where there is no other reasonable means of access to the terminal, to public roadway, river, creek, or foreshore. Right. So in this scenario, it's actually a right if you are an inner land owner that you are naturally able to gain access to your inner land. In fact, you can say, well, the outer land owner has to give you that right. So this is protected in the law by Sarawak Land Court. So anyone who has a license or permit to do rock material, forest produce inside the inner land actually would use this section 34 right of way to enter another person's land so that to achieve entrance to his own spot, his own location to do the work. So this means that including holders of license, permit, holders of mining lease or prospecting license who has to enter to the inner land, this law provides, the section 34 provides entrance for the right to enter, shall have a right of way for all reasonable purposes over such land to pass and repass it or without boats or vehicles. So this different. That means you cannot say he trespass your land, because the Sarawak Land Code 34 says that right of way, if he needs to go into his land, he can use the entrance through your land, and he doesn't have choice because there is no other reasonable means of access. So this part is not found in National Land Court as much. National Land Court, you have to go and apply the land administrator's right of way for you to enter. So what if it is unhappy disallowed by the outer land proprietor? So in 34.2 for the Sarawak Land Court, the superintendent of the land office can have the power to decide. So the person outside land owner not happy, or you go and just simply come to your place, take your things and never inform me. I get things missing in my place. How? So this superintendent would have to decide. So you can complain to the land office superintendent. The superintendent would do something about it. Is there any proof of such right of way? If let's say after the cases has been highlighted to the superintendent can, in a case where the right of way for the benefit of the proprietors and occupiers adjoining land has been created using the form just now, which the superintendent issued a right of way certificate, which is proof. So you have this certificate. So at any time you need to show me the certificate before you enter. Maybe that would be a more appropriate way of just simply bulldoze through to the inner land. Yeah, now that you bulldoze through my land, compensate me. So section 34, subsection 5 of the Sarawak Land Code also says that, well, if you are affected, yes, you can ask for compensation from the dominant land. So person inside need to pass through your land, but he destroy your crops, destroy your building or destroy your construction, and this costs a lot to repair. So this means that you can bring the matter up to the superintendent and ask for compensation, which will be assessed by the superintendent lah. However, if let's say you are not happy, let's say still the outer land owner still not happy, you can bring it to court lah, to high court, appeal to high court, and to get the thing settled lah. So is there any other reason for this case, like besides roads, accessibility issue, any other reason that the adjoining land proprietor can ask for right of way? So here it says that yes, I was talking about this part earlier on about the accessibility, not just on physical accessibility, but also the right of enabling owners to drainage and irrigation in section 35, section 36, right to prospect for mineral. Let's say there is a potential mining of certain mineral, and the prospecting company wants to go in. Maybe the surveyor wants to go in, the geologist wants to go in, then they need to bring the heavy machinery in. So this heavy machinery will sort of go through a stretch of road, and therefore may incur damages, and that part need to be compensated of course. But then there is the right to prospect for mineral. There is a permit and there is a mining certificate or mining lease. Then the person has to allow the proprietor of the outer land has to allow. This is in the section 36. And also if it becomes a government's right for doing things inside, and therefore they need the drainage, irrigation drainage, then you pass through your land. That is the right of the purpose. There is a right of purpose under 37. 38, the margin of land along all rivers, seas, coasts, roads, borders reserved to government. So this is reserve land in the sense under the land classification. There is a part of the reserve where a certain portion of the land would be reserved for this purpose, for 66 feet on each side of the bank. So let's say the reason is that he builds a certain drainage to the river outside. The river pass through your land, and his drainage longkang actually also pass through your land, and this part the longkang passing through is of course under the enabling owners to drainage and irrigation. But then the river passing your land now become bigger because more water, let's say more drainage, more water, then the river needs a bigger reserve. So this bigger reserve also affects your land. 66 feet on each side of the bank, 33 feet on each side of the center for all roads maintained by the government or local authority. So these are standard in the sense that if you have a plot of land and there is a road passing through it, then you would be compensated for the road, the area that the road is taken away from you, and plus the reserve. So National Land Court, the land administrator's right of way, I just briefly cover for the benefit of the state authority or proprietor or occupier is called the private right of way, whereas for the public, that we mentioned just now, for any other person, it's called public right of way. And then is there any proof? Let's say you are looking at this right of way for going in and out for a period of time. Then there is a Form 28B on the register document title to carry this. So the land office would put a note, or we call it a memorial document or title on a document or title to say that there is a section with the layout plan saying that there is a right of way given to inner land. So this means that there is a form to fill and to draw up a specific area where it becomes a right of way, becomes the pathway or passageway, and this will be attached to the land title of the affected land. In this case, affected land is the outer land. So let's continue. So the procedure of the creation of the right, the registrar who receives the receive already this form shall make in the document of title and the issue document of title a memorial of the right of way showing its route, either by means of a fresh plan or by means of an amendment of any plan already endorsed thereon. So that's how we were saying you apply with the form, put into drawings. Therefore, the registrar, upon receiving this, will do the necessary and put it in the document of title and issue document of title. Right, we spoke about register document of title and issue document of title in the earlier chapter. So go back to the earlier chapter compensation procedure also given in the National Land Court 393 compensation, where it's the same concept That means you affected my land, you have to compensate me. So the inner land owner has to compensate the outer land for the use of the stretch of road for the part that it is affected. So it means that the land administrator's right of way created, the person who has been affected actually can demand compensation from the party who initiated this land administrator's right of way. The amount of the compensation shall be determined by the land administrator. So in Sarawak is by the superintendent, by West Malaysia is by the land administrator. 395 talks about extinction of right. So if the land administrator given this right of way and later on want to discontinue it or to extinguish it, it can be decided and be extinguished as in no more. So that means cease to have the right of way. I would like to conclude the presentation this afternoon. We went through easement versus right of way, comparing the differences between them. We also spoke the general information on what easement is about and also what is right of way. We started also some specific area in easement, like you giving example just now for passageway into inner land or for government purpose and things like that. And we also talk about specific for Sarawak. There is a section 34. This is specifically for Sarawak, not found in National Land Court, that implied right. The Sarawak Land Court gives an implied right for the inner land to be accessible from outside. This could be due to Sarawak being big geographical land area and there are not many road accessibility. So therefore, to allow entry to your land, to work on your land is inevitable in that sense. So the law, the land court provides that as an implied right. When we spoke about right of way in Sarawak, although Sarawak there is no term as land administrator's right of way, it's just the simple term right of way. Sarawak still refers to superintendent of the land and survey. So land in the states of Sarawak for right of the way is specifically protected. We also spoke about land administrators right of way under the National Land Court in a case where specific for passageway, as well as we spoke about easement. Easement in National Land Court is actually a specific part. National Land Court provides a land administrator's right of way for documentation or memorial to be entered into the register document of title or to be given out as a issue document of title. For Sarawak, it's given as a certificate, the right of way certificate. Both land courts also provides compensation, a way of compensation in case the adjoining land have been suffering from the entrance damages. So the adjoining land has a right to ask for compensation, and compensation will be decided by the superintendent in Sarawak or the land administrator as in West Malaysia under National Land Court. So if the bigger places, it will be under the registrar of the land office. Thank you very much for listening to my presentation on right of way. I am Thomasin PA 2066. This is my mobile number. I have a few websites. Findway.info is a geo-linking advertising website for agents. Estateagentexam.com is a website for online self-study of the estate agents examination. So this estate agents examination, upon completion, you can gain recognition under Section 22D to be registered as a PEA. My Real Property Online collection of my videos, 160 plus videos now, and also some of the listings and write-ups. Contract2you.com website for research area I'm into, which is a comparative index ranking of properties. Baker's Real Estate.fund, a simple, easy to build website for real estate agents. Thank you for visiting my website.